Hi guys, thank you so much for subscribing once again to Talk With Ọlá, and that's a thank you in advance if you have not subscribed. Today we want to continue the series, What Does a State Counsel Do? So this is episode 4, and we're going to be talking about the other things that a state counsel does. We've talked about filing counter affidavits, we talked about bringing witnesses to court, we've talked about tracing files, prepping witnesses for trial, and several other things. We're now going to be talking about the other things that a state counsel does that makes up the totality of prosecution is what we want to talk about today. Please leave me a comment in the comment section when you've seen this video. And for people who ask questions that are standalone questions, it's important for you to watch a video on the channel and then ask questions based on that video. Else, you're saying, oh, I've looked through the channel, you have not done anything on this area of law, and that's why I'm asking. If you are not asking from these two angles, I think it's necessary for you to book a paid consultation session or pay for a document review advisory slot to ask any other question. And this is because most likely what you're asking will only benefit you. If you're asking someone something that will benefit every other person, we are happy to answer. We are happy to do a video on it. So please, this is not a place for you to come and dump your school assignments, and it's not a place for you to co-opt Talk With Ọlá as a co-counselor in your matter in court. No. What we do here is legal education, entertainment, and information. So essentially, we expect that you look through the channel to see which video answers my question the most, or which video is closest to what I'm looking for, and to watch it. Then if you have questions that have not been addressed by that video, you then ask in the comment section or by email. Or you come and you say that you have not done anything on this area of law, please do a video on it. But not that you say, oh, this is my matter that I'm doing in court, can you advise me on so and so, or should I do this, what should I do, what can I say? Book a paid session if that's what you want, so that everyone can be happy, and so that you not co-opt us into a liability that we shouldn't be bound, by or with, because what we do here does not constitute legal advice such that you cannot hold us responsible, as your counselors or your lawyers when you act on it. But if you would rather do that, book a paid session and establish that lawyer-client relationship nice and clear. So another thing that the state counsel does is amendment of charges. Very important. It's one of the things that I did a lot, as state counsel, amendment of charges. And usually or sometimes, charges are defective. We've talked about charges. We have a whole video on charges on this channel, and we talked about defective charges. They are very dangerous because the entire case can crumble on them. So it's important for a charge to be safe, to be solid, and not to be defective. So if a charge is defective, the law permits the prosecution to come at any time before the matter is decided to amend the charge. What are some of the things we amend? It could be the time of offense, it could be the name of the parties, it could be the flavor of the offense, it could be anything. So amendment of charges is one of the things that we do most. I'll give you an example. In a murder trial, one of the defendants jumped bail, and we had tried to enforce the bench warrant to look for him. We couldn't find him. His lawyer had died, and so he stopped coming to court. And we kept on adjourning the matter because of him. So eventually, the court was furious. The court was going to throw out the case if we did not amend the charge to strike out the defendant's name. So the court actually said, strike out his name and let's move on, or I'll throw out the charge for want of diligent prosecution. So what we now did was we filed a motion for amendment of charges to strike out his name pending the time when he can or will be rearrested and then tried, so that we could move on with the rest of the defendants. So we filed a motion for amendment. So I did it and we filed it. Now, amendment of charges is a serious matter because it can make or mar your case. If you're not very smart and careful, each time I have to amend a charge, about 3 or 4 prosecution counsel look through it. Like we look through it, we exchange ideas, so that we are home and dry. One time when we amended a charge, we kept on re-editing because it was, very confusing and dicey, for prosecution. Sometimes cases take years, so it could be that at the time they even started the matter, you are not even part of the team, so a lot of things could be lost on you. Then you try to decipher from the evidence. This was a very, very old case. In fact, one of the prosecution counsel that started it several years earlier had become a judge by the time that I was in that matter, for you to know the length of time. So when we filed the amendment, and the lead counsel now moved the motion. Now, to amend the charge, we had to substitute the new charge for the old charge before the court. So the court had to strike out the old charge, and then we brought the new one that was defective in its amendment. So that means essentially if we leave the court that day, there's no charge before the court, those people can go home free. So the mistake that we made in the amendment, when the court called our attention to it, in order to correct it, our lead counsel now said, "Oh my lord, we are withdrawing it." Meanwhile, we have already withdrawn and had struck out the old charge. So if we now that was the mistake, I remember clearly now. So it wasn't the amendment that would have discharged the defendant, but because we had struck out the first charge, the old charge that contained the name of the defendant. Yeah, it was the amendment for that murder trial, I remember clearly. So because we had struck out the name of that defendant that had jumped bail, we had struck out his name. So in our amendment, so we had asked the court to strike out the old charge before it, to substitute with the new charge that we were now bringing by a motion for amendment. So the court called our attention to the mistake in the new charge that we were bringing by a motion for amendment. And then lead counsel now said, "My lord, we are withdrawing it." So God saved us that the court said we could not withdraw it. Because if we had withdrawn it, and the defense counsel were waiting for us, because they then told the lead counsel after we had passed that stage that we were waiting for you to actually withdraw that new charge too, because of the mistake that the court called your attention to. If you had withdrawn it, since you had struck out the old charge, that means there will be no charge before the court. We would have just asked for the discharge of our defendants in a murder trial. So it's serious matter, amendment, serious matter. So that, I remember another instance where I made an amendment for a charge. The state counsel that prepared the charge are charged for breaking and entering, but the thing had happened at night, and by law, if it happens at night, it's burglary. If it happens during the day, it's breaking and entering. I had to do a motion for amendment and bring the amended charge by that motion to amend and deem the amended charge as properly filed and served, for the court to change it from breaking and entry into burglary, so that we could move on in the case. So amending charges is one of the most important things that a state counsel does where a charge is defective. And the defect could come from the officer drafting the legal advice. It could come from, insufficient evidence forwarded in the police case file. It could also come from, new facts coming up in the matter. I remember there was a time where to do an amendment. We didn't eventually do it before I left before I stopped working with the PPD, but what happened was that we had opened a kidnapping trial. I had brought witnesses to court, and we had put first witness, second witness in the box. And then we discovered that from the proof of evidence, the police had arrested more than the two defendants in the dock. So I traced that information, and then I traced it to the magistrate court, because we are at the High Court, and I realized that there was actually a pending charge at the magistrate court that had not been dispensed with, even though we had opened the main kidnapping trial in the High Court, because the High Court had jurisdiction. So I realized that the people that had drafted the charge had failed to include a very key person that was arrested, whose statements was in the police case file, who was referred to severally by the other two defendants. So I had to trace that, so my superior said that, okay, trace it. Then when we find it, we're going to bring that person in and amend the charge so that they become one of the defendants. So sometimes that happens. So sometimes charges need to be amended, and that's one of the things, one of the jobs of a state counsel. Amendment of charges could also be necessitated by the need to add to the charges. For instance, in a murder trial once, we had to add unlawful society to the charges because from the totality of the evidence, these people were members of an unlawful society. So it was like a society versus society clash, a cult versus cult clash. So they had killed their leaders, and we had to add unlawful society, membership of an unlawful society to the charge sheet. So we did an amendment of charges. Now, this is not to say that state counsel is incompetent, but because we work in departments, a different person is drafting the charge, a different person is prosecuting most times. So when the prosecution comes to us, we were prosecuting, and then we look at the totality of the evidence, we see, oh, there's a need for us to add this and that. We were prosecuting one matter once, and we realized that the witnesses that had been listed that we had brought to court, some were even coming from outside town, we realized that the charge that affected them, it was a robbery matter, and the robbers had, within the same time frame, visited different locations to rob people, snatch this person's car, rob this person at gunpoint in their house, do this, do that. So the one that particularly happened to the witnesses that showed up in court was not included in the charge. So we needed to do an amendment to include that charge so that these witnesses, they can give evidence, and the evidence can have a lawful basis because the charge that concerned them was now in the charge sheet. So different things that the state counsel needs to do, and one of them is amending charges. After amending charges, we need to move a motion for amendment. We file it in court, we serve it on the defense counsel, and then we need to come to court to withdraw the old charge and substitute it with a new charge, and move a motion to for amendment, for the court to grant the order of amendment and to deem what we have already filed as properly filed and served. In some jurisdictions, you can't do a deeming order. You have to first come and ask for an order of to amend, and then you come back and tell the court we've amended, now accept our amendment. But in our jurisdiction where I practice, we could do a deeming order so that we could just ask for the three at the same time in order to amend and to deem what we've amended as properly filed and served, and then we substitute the charge there and then so that we can move on. Because we were at the High Court, you cannot do those things orally, so we had to file these things properly. Another thing that the state counsel does is withdrawal of charges. We withdraw charges before the court. This is one of the things that state counsel are most reluctant to do, because it looks like child's play. We're the one that brought the matter to court. Why would we withdraw again? But sometimes it's necessary. In fact, the court would even recommend sometimes that we should withdraw, in not so many words. And the reason for withdrawal could be that, we've been taking adjournment for so long and we've been unable to bring our witnesses to court. It's difficult, exceptionally difficult to bring witnesses to court in a criminal matter in Nigeria, because most people pepper body when they go and report the matter, when they now realize that the state has taken it serious and wants to prosecute. They say they are not interested again, or they didn't think that it would be that serious, or they've moved on with their lives, or they don't even have the time to come to court, giving so many excuses. We've dealt with that in the previous video on what a state counsel does. But sometimes when we cannot bring our witness and we've been taking consecutive adjournments, the court would even suggest, why not just withdraw this charge? Alternatively, the defense counsel can ask the court to strike it out for want of diligent prosecution. We even prefer that as state counsel, because then the responsibility will not be on us to withdraw the charge, because withdrawing a charge can be very dicey or tricky. You could withdraw a charge today because of the necessity. You cannot continue the matter. Maybe the IPO that investigated that was supposed to give evidence in the matter has been transferred on peacekeeping mission outside the country. The civilian witnesses have refused to come to court. You have done everything within your power to put the case together and let it go to trial, and it's not going to trial. So you are just coming to court to take adjournment upon adjournment upon adjournment. And the next thing for you is to withdraw. So you withdraw. Maybe tomorrow a government that does not know Joseph will come to power in your ministry, And then they start looking through files that have been withdrawn, and then someone would now suggest or insinuate that maybe somebody settled you or somebody paid you off to not do the case, and that's why you withdrew it. So state counsel are very reluctant to withdraw charges. That's why you will see that some cases are in court, they are pending for so long, the state counsel is just coming to take an adjournment. It's easier if the defense counsel will ask the court to strike it out, and then the court will strike it out for want of diligent prosecution, than for the state counsel to withdraw. But in some cases, the state counsel will still withdraw. I'm just trying to show why it is exceptionally difficult and why state counsel are often reluctant to withdraw the charge. And also because it makes you look unserious. Like, are you not the one that came to court and said you want to prosecute this matter? Now you are saying you are not prosecuting again. What are you doing? So, so many constraints for a state counsel, but one of the things that the state counsel also does is to withdraw the charge. And of course, the most important of them all, the state counsel goes to trial. Trial is very important. We've talked about examination in chief, re-examination, cross-examination on this channel. Please watch those videos. I've even done that for criminal matters. I've put the IPO on the stand before in some videos on the channel. I'll see if I can collate all those videos into a playlist. But if you just check the criminal prosecution section of the playlist, you'll see all these things. One other thing, a very key part of state counseling or state counsel work is going to trial. We put the defendant, we put the suspect, who is now the defendant, in the box, and then we call witnesses in their matter and to testify against them and to testify in support of our case. And then our witnesses are cross-examined, and we re-examine them if need be, and then we cross-examine the witness of the defense counsel or the defendant as well, and then the case is closed, after which we take a day to file our written address. Now, in Nigeria, we don't do oral address anymore. So everyone asking for a video on adumbration, you don't need it in a Nigerian court. Most judges will tell you, what do you mean? I can read. Those things you're saying, are they in your address? If they are there, please round off. And that's because they need to move on. So oral address is time wasting. It's no longer a thing in Nigeria. Everything you need to say, you've already put down in your written address. So we just go to court, we adopt our written address. One of the earliest videos that I did on this channel in 2021, January or February, was the adoption of, is it was or is, was, whichever one, the adoption of a written address. And that was the first thing that I did as a prosecutor. I adopted the written address, the very first thing. Like, I was posted to my department where I was going to work today, and I got the director said, you're going to court tomorrow, you're going to go and adopt this written address. That was the first thing. I did a video, I recorded the adoption. So if you watch that video till the end, you actually listen to the live recording of my adoption of the written address. It was a rape matter, and we got judgment in our favor. The defendant was convicted and sentenced. So adoption of written address is also something that the state counsel does, after which we take judgment in the matter, just like in any other case and for any other lawyer. And if there's an appeal, we reply, we respond to the appeal. So these are the important things that the state counsel does. There's another thing I remember, I'm going to put it in another video making number 5, but if not, this might be the end of the series. What does a state counsel do? So essentially, we've talked about what a state counsel in the public prosecutions department does. I've told you there are several departments. I worked in public prosecution part-time, and then I mainly worked in the mediation center. I've done a full series on mediation on this channel. Too many videos on mediation because it was my main department, but several other videos also on prosecution work. And now in these 4 videos in this series, we've talked about what the state counsel does from the time that the police forwards the duplicate case file to the public prosecution department to the point where we receive judgment in the matter. I hope you have learned a thing or two, and I hope that you will continue the conversations in the comment section. Don't forget that if you have any challenge and you need answers or advisory, which going to be tailored to you. You should book a paid consultation session using the link in the description box, or send me a mail at houseofdivingstones@gmail.com indicating that, and I'll put you through how to book, and we can schedule a time and talk. But if you have a question which answer will benefit other people, leave it in the description box right away, or leave it in the comment section, and we'll get to it as soon as possible. I'll see you in my very next video. Don't forget to subscribe. Toodles.